Honourable Member for Toronto-Danforth.
Mr. Speaker, I am privileged to rise for my inaugural speech in the House of Commons since my election as the Member of Parliament for Toronto-Danforth. Permit me to begin by first thanking the people of Toronto-Danforth for having placed their trust in me on the March 19th by-election. I recognize that the bar has been set very high, in that I have both the distinct honour and the distinct challenge of succeeding a truly great member of this House, the Honourable Jack Layton, whose untimely passing this past August 22nd triggered an outpouring of emotion across this country amongst Canadians such as this country has rarely known. I pledge to represent the vibrant community of Toronto-Danforth tirelessly, with integrity, and following the example set by my predecessor. That is, like Jack Layton, I will do my utmost to contribute to Parliament both constructively, working with others to secure just and sensible results, Mr. Speaker, and by resolutely defending the progressive values of the people of Toronto-Danforth. In that spirit, I turn now to address the substance of the legislation before the House on second reading, Bill C-31. This omnibus bill is intended to amend a variety of existing statutes, most notably IRPA, the Immigration and Refugee Protection Act, and the Balanced Refugee Reform Act. The Balanced Refugee Reform Act is itself mostly a far-ranging effort to amend IRPA, and the ink is still wet on it, in that it only enters into force at the end of June. It is important to recall that the Balanced Refugee Reform Act was ultimately a product of hard work and mutual compromise from all corners of this House, having been adopted with eventual all-party support. Less than a year after it achieved a majority in the House last spring, the government is abandoning compromise and is steamrolling ahead with its own particular, uncompromising view of refugee policy. In support of this characterization of the government's Bill C-31 legislative initiative, allow me to briefly discuss a few, and I emphasize only a few, Mr. Speaker, of the disturbing additions or changes to refugee law that Bill C-31 will usher in if it is permitted to pass. First of all, the Minister, if he deems it to be in the public interest, may characterize a refugee claimant or refugee claimants as having arrived in Canada irregularly. This decision turns these claimants into designated foreign nationals, and I may subsequently simply refer to DFNs. Crucially and shockingly, this designation as DFNs subjects them to automatic detention. In contrast to regular refugee claimants whose detention must be reviewed after 48 hours and again in 7 days, and then every 30 days thereafter, these irregular claimants can remain for 12 months before there is their first review of their detention. Indeed, for good measure, Bill C-31 explicitly adds a provision saying that review is precluded before the end of 12 months. Thereafter, their detention is reviewed in 6-month increments. Little could run further afoul of international refugee law's strong presumption against detention, which requires a stringent necessity test to be made out, and of international refugee law's requirement that the necessity of detention be subject to early and then frequent review. Now, under the Balanced Refugee Reform Act, a refugee claimant has access to a full appeal to a Refugee Appeal Division panel. But now, under Bill C-31, a designated foreign national, this second-class refugee created by the Act, can no longer access the appeal process established in the Balanced Refugee Reform Act if the first instance decision-maker, that's the Refugee Protection Division, denies the person's refugee claim. Not only does she have no right of appeal, but she is subject to immediate deportation. It's true that the DFN refugee claimant still may seek what is known as judicial review, but it's very important, in light of the answers being given in the House before the break, that this is not the same as an appeal. It is a much more limited process. It's found in the current law. It removes the automatic stay of deportation found in the current law, so that in many, if not most cases, judicial review will occur after a person has been removed from the country. Now, what of a designated foreign national who is successful in the refugee claim, who is recognized as a refugee? Surely, Mr. Speaker, at that stage, Bill C-31 must provide that the successful claimant gets treated like any other refugee. But, unbelievably, no. To start with, the designated foreign national who's recognized as a refugee continues to wear that designation as a state-imposed badge of dishonor, being subjected to reporting requirements that other refugees are not subjected to. More atrociously, an accepted refugee who started out as a designated foreign national cannot apply to become a permanent resident of Canada for 5 years after being found to be a refugee. This could result in the refugee not becoming a permanent resident for 6 or 7 years, if you assume that there will be processing delays with some applications. Compare this to a regular refugee who is actually required to apply for permanent resident status before 60 days are up. But what's the big deal, one might ask? If a refugee gets to stay in Canada, what difference does it make if she has permanent residence or simply some sort of refugee status? Well, one huge difference that it makes is that IRPA, the Immigration and Refugee Protection Act, requires that a person to be a permanent resident before they are able to sponsor family members to immigrate to Canada, one's spouse, one's children, one's parents. Thus, Bill C-31's irregular refugees have no hope of reuniting with family in Canada for at least 5 years. And then, Mr. Speaker, when one realizes that currently family class applications in this country are often processed at a snail's pace, with it not being uncommon for it to take 3 years for a child or a spouse to be admitted, and sometimes up to 6 years for parents. It's no stretch to say that a refugee who started out as a designated foreign national may have to wait 10 years to have family join her or him here. And if that's not enough, a designated foreign national refugee will not even be able to arrange to travel outside Canada to spend time with family, for example, in a country other than the country of origin that they fear going back to. Why is that? That is because Bill C-31 decrees that such a refugee will not be given travel documents until she becomes a permanent resident. That is, until at least 5 years have passed. This, despite the fact that the Refugee Convention requires that travel documents be issued to refugees once they are, quote, lawfully staying, unquote, in the host country. Fortress Canada thus becomes Prison Canada for the designated foreign national refugee. Now, if he were still alive, Kafka could not have written Bill C-31 better if he tried. And it doesn't end there. The DFN provisions apply retroactively back to March 2009, such that the minister could, for example, decide after Bill C-31 becomes law to designate the Tamil refugees who arrived on the Ocean Lady in October 2009 and the Sun Sea in August 2010 as irregulars. And the only part of that DFN regime that does not apply retroactively is the detention regime. I thank you very much, Mr. Speaker. 1 minute left. Finally, there is the stunning change in the law with respect to cessation of refugee status, which basically means that the government, after they apply to have a refugee status removed, that also simultaneously removes their permanent resident status, which subjects them to being removed from the country. Time does not permit me, Mr. Speaker, to go into many other problems with this bill, such as problematic changes to the Safe Countries regime, the implications for children, the radical cuts in the time that refugee claimants have to prepare their cases, and the advent of a biometrics regime that comes with no privacy safeguards and that allows Canada to share this data with other countries. There is much that requires close and exacting scrutiny once this bill goes to committee. And I hope that the opposition, that the government members, along with the opposition, will take very seriously that committee process and not back the government in what is ultimately repressive legislation. At some point, MPs have to stand up as MPs and stand up for their conscience as well as for the constituents in this country. Thank you very much, Mr. Speaker.
Bravo.